I'm in court.
Counsel, I've called this case. Counsel, I've called the case and we're on the record. And so you just stepped out from right here and answered your phone while we're on the record in court.
I apologize. I answered because I have another client that I suspect may be going to jail today in Monroe. I will not do so again. I apologize.
So counsel, then what?
Chief Surratt, 33828, appearing on behalf.
Hold on. No, everybody right back up here. Right back up here. Miss Lambert included. Miss Smiley, you can come back up this way. Miss Lambert, please, we're recalling the matter of Kenneth Lambert. Ma'am, please state your name for the record.
Kathy Lambert.
Okay. So I'm going to place on the record, because I don't know that counsel saw this, but the court was watching the body language and the behavior as Miss Smiley as the parties were leaving. Mr. Lambert was walking back to his wife, and then Miss Smiley was walking out. Miss Lambert apparently found it necessary to stare her up and down and stare at her as she was walking by.
Can I speak?
No, you may not. You may not.
Okay. Go!
Hand me my screen box.
Now go freak.
All right, good morning, and thank you for dressing appropriately for court for sentencing today, which can't happen because you didn't order 6 last night on a Sunday.
Yes, Your Honor.
When, just so you know, probation's not here at the time or day.
I'm amazed, Your Honor, on behalf of the defendant, it's the first person under the age of 30 that doesn't check his email. But his father's here with him.
Well, yes, but I'm not as amazed because I find that apparently email is not the means of communication for younger people anymore. It's Instagram, Snapchat, and if it's not on there, then they're not getting the information, right?
I know.
Speaking of generosity,
Instagram might not work for PSI. They put everything else on it. If you'll grant us graciously the opportunity to come back, he filled it out. We can come back next Monday, Judge, if that works for the court.
Well, here's the thing, right? So, next Monday works for the court, but the problem is that, so I sent this out from May 27th, what is that, 6 weeks? 5 weeks? Whatever it was. It was a long
March
time.
22nd, yes, right.
What did I say, May?
May, but that's
Oh, yes, not March.
That would be a real long set.
Sure
Well,
would be,
we've
yeah,
got
so-
some problems outside. Come back this week, Judge.
So I did it for 5 weeks because that way it gives my staff an opportunity to review everything, make the recommendations, type up the report, I can review it. So now if I'm going to have you come back in 1 week, then they have to now push somebody else aside and hurry up and get it done. So you were emailed twice. And when you left here on March 27th, you went over to probation,
yes,
right? You got the information and they said, we're emailing it to you, or what have you, and you have to send it back.
That's right.
So you're telling me in 5 weeks, up until yesterday, you didn't check your email?
I don't check it often, but I must have checked it probably a week after it was sent, so it must have been pretty deep down my inventory. But I'm not trying to make any excuses for myself, but on that date, it's possible. I wouldn't doubt what you guys told me about it, but I was very nervous, frankly, and I probably didn't retain every word that was given to me, but again, not trying to make any excuses.
So, and I wouldn't have told you that. That would have been strictly probation because that's their thing. But my other question is, you went to probation, right? So tell me everything that happened. You left here, the courtroom, went over to probation.
Yeah, I went straight to the probation office, and Mrs. White informed me of everything that I had to do, and
Which was what?
Which was fill out the survey via email.
Okay.
Yeah, that's pretty much all I remember currently, but
Okay.
yeah, that's pretty much it.
All right, and, did anybody tell you what the purpose of the survey was?
If they did, I don't recall. Well, again, I wouldn't doubt that they did tell me.
Okay. And so knowing that today was sentencing, I mean, how was it that you saw it yesterday?
Mr. Zelnick actually notified me yesterday via phone, and,
All right, because you had gotten the summary that you had not contacted back into us.
well, repeat that, Council.
Because he received the email from probation that they couldn't put together a recommendation or a report and recommendation because you hadn't responded and sent the email back.
Yes, sir.
Is there, you work?
I do.
Where do you work?
7 years.
Okay. And how do they communicate with their staff?
Mostly via a group chat and like iMessage or any sort of text message.
Okay, there's nothing that has to get out to the whole company that, they send in like company emails?
They do send emails sometimes, but most of the emails don't apply to me. It's mostly project managers. So that really wouldn't apply to me too much, but on a rare occasion, it would.
So do you receive the emails and you just don't need to do anything with them, or you just don't even receive them?
I wouldn't really know if I receive them or not, because like I said, I don't check my email often at all, maybe like once or twice a month.
Not even your work email?
Not often. It's a bad habit, but
A little bit.
yes, Your Honor.
In the professional world, you absolutely need to be checking your email.
I agree, absolutely.
I mean, you could have missed some important surveys about something to do so you can get a raise. I mean, I don't know.
Well, the other thing is he could have inherited about $100 million in Nigeria too, and he missed that. There's an awful lot you miss when you don't check your email.
Definitely.
Yeah, now, you have lots of spam, so you don't have to worry, I mean, I'm sure, but at the end of the day, Mr. London, you need to check your email on a regular basis.
Absolutely, I agree. And again, my sincere apologies for any inconveniences I'm sure I've made many inconveniences with you guys, so, I sincerely apologize for that.
Well, and I appreciate that. I mean, we're inconvenienced a lot, so that, I mean, that doesn't really, at the end of the day, that's, a small, issue as opposed to, everything else. I mean, so now you have to take another day off of work. Or morning or whatever it may be. I suppose, well, how else, if you're not here, how else am I supposed to do the sentencing? Do you work you work during the week, right?
6 days a week.
If you were to test what's in your system,
Nothing that I won't be able to drink or take, like drugs or anything like that.
what do you mean, nothing that you wouldn't be able,
Like no alcohol or anything like that.
okay, you didn't go celebrate Cinco de Mayo yesterday?
No, Your Honor.
Does May 21st work, council?
It sure will, Judge. I'm just looking at your calendar to see. That's a Tuesday.
Yes.
We'll make it work.
What time works for you, Mr. Zelnick?
8:30. He was here at 8:30, Judge.
I've been here since 7:30, just so you know, I wasn't out here, but I've been here since 7:30.
I was probably more severe on him yesterday. That's why I brought his father, because I told him off yesterday. You were very gentle with him and polite, as opposed to what I told him yesterday.
Well, you can be that way. I have to be a little bit more,
Diplomatic.
Yeah.
Judicious.
Good word. Okay, let me be very clear, Mr. London. You do not respond to any outreach or communication with probation. And then we have to then adjourn this another time. Even if you don't respond within a reasonable time, and I would say that a reasonable time would be within 24 hours. At the very latest. That will be a bond violation. Okay, and Mr. Zelnick can tell you what happens sometimes with individuals that violate bond.
I have the record from last year.
Yes. So May 21st, 8:30 a.m. Please stop at probation. See if there's anything that you need to do. And if you need to take a few minutes before you go there because you're nervous, sit out in the lobby, let it sink in, and then go over to probation. Okay? Don't be afraid to ask questions. If you're not sure what the next step is or what you need to do next, Don't be afraid to ask questions.
Absolutely.
And if you need to, until you get in the habit, put an alarm on your phone. Right? Like every couple hours, check email. Check work email, check personal email. But you need to be in that habit because that's, clearly you miss important information.
Yes, Your Honor, I agree.
All right, we'll see you back May 21st.
Thank you, Your Honor.
All right, have a good day. What are you gonna do next right now, Mr. London?
Go to the probation office and see what I have to do.
Okay,
Very well. Thank you, Judge.
you're welcome. In the matter of the city of Riverview versus Erica Jackson, 24327 AB.
Your Honor, good morning, Richard T. Serrano, P33828, appearing on behalf of my client, here to my right, for arraignment pretrial today. Please state your name, ma'am.
Erica Jackson.
Okay, good morning. All right, so let me just clarify something right now. I see that the victim in this matter is Rachel Grote.
Correct?
Okay, so, I know who Ms. Grote is. I haven't seen her for a little bit, and I for sure have not spoken to her regarding the matter. And she is related to, members of the police department. So I just wanted to put that out there on the record, so that you understand, ma'am, that I do know this person. It doesn't in any way affect, my ability to preside over this matter, fairly or impartially. Do you have any concerns with that, ma'am?
We've talked about it, Your Honor. I told her that the victim was related to one of the Wyandotte police officers. And
Technically three, but
Pardon me?
technically three.
Oh, okay, yes, correct. Okay, but no, we have no objections. Is that correct, ma'am?
That's correct, Your Honor.
Okay. All right. I'm sorry, counsel. As to the arraignment?
Your Honor, I explained to my client the nature of the charges, all the maximum penalties, all of her rights. She understands both. Therefore, I'm waiting for her to understand you today.
The court waived the formal reading, enter a plea of not guilty for purposes of the arraignment, and then ask the pretrial counsel.
After pre-trying the matter, Your Honor, my client was to avail herself of the offer and that she will admit guilt to the amended charge forthwith. I've explained that, what that means to her. Also, she will plead responsible to the amended charge of having no proof of insurance. You understand what that entails? Then if those pleas are in fact accepted by this court, then the motion of the prosecutor will be dismissed, the original charges, as well as the failure to stop and ensure the distance ahead causing the accident. And she's been advised her rights, it's ready for the first examination.
Okay. All right. And so, ma'am, can you please raise your right hand?
I did.
All right, thank you. And you heard the plea that your attorney placed on the record, correct?
I did.
As to the amended charge, failed to report accident, how do you plead, guilty or not guilty?
Guilty.
And as to no proof of insurance, how do you plead, responsible or not responsible?
Responsible.
If you can please run to your client, counsel.
Ms. Jackson, on March 14, 2024, approximately 11 in the morning, were you operating a vehicle in the city of Riverview?
Yes.
At that time, you became involved in a multi-car accident, is that correct?
Yes.
And upon the police officers later, in your version of it, they had to stop you because you did not report the accident right away, is that correct?
Yes.
And at that time, you also had no proof of insurance to show the officer, is that correct?
Yes.
I'm satisfied.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement, and this was in the city of Wyandotte, correct? Under Riverview, correct?
Yes, we established that, Your Honor.
All right, the court's going to accept your plea as knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement, dismiss the originals per the plea agreement, and we'll schedule this matter for sentencing on May 29th. And as to bond counsel.
Your Honor, my client was not arrested in this matter. She was cooperative with the police officers. She's single. She has a 16-year-old son, Your Honor, and she works now, but money is going to be tight for her. So I told her that hopefully the court will allow her to pay over a period of time, but that will save for sentencing. And we've asked a personal bond, Your Honor, a bond she could reasonably expect to post. Also, I would mention that the restitution was part of the plea bargain, Your Honor, for the victim's pocket deductible.
Yes, and so ma'am, you understand that you do have that, the $1,000 that you've agreed to regarding the deductible for the, Miss Grove's car insurance, correct?
Yes, Your Honor, I just need time to pay it. If I could.
Okay,
Oh,
all right. Okay, have you ever failed to appear in court for any reason?
no,
You currently have probation or parole anywhere?
no, ma'am.
And do you work?
Yes, ma'am.
Where is it you work?
I'm assistant general manager at the, on West Road in Woodhaven.
Okay. And so ma'am, what happened this day? Why'd you leave? Why'd you stick around?
My accelerator got stuck to my motor and it flew, so I was scared. When the accelerator stuck to the motor, it flew me, and I was trying to avoid people, not to hurt anybody, so
Okay, but after you hit her, you were stopped, so you left.
it bounced me back and flew me. So I'm, Your Honor.
All right, the court's going to order a $5,000 personal bond not to possess and consume any alcohol or drugs that are not prescribed. Please have a seat over probation. Somebody will be with you shortly.
Thank you.
Thank you.
Thank you. Oh, I'm sorry, hold on one. And your license valid, ma'am?
Yes, Your Honor.
Yes.
I did have $900 worth prior done to my vehicle when this happened, so I don't know if that caused me to everything to whack up. So I just wanted to add that in, I'm sorry.
No, that's okay. I mean, accidents happen,
Yeah.
right? But sticking around and trying to,
I know.
but even while you were, unexpectedly accelerating, I mean, did you try to contact anybody for help at any point,
I
or when you
was so
stopped?
scared to hit someone else. I was even at one point wondering if I should hit into a building and stop myself, but luckily my car just died. So I didn't hurt nobody, and nobody got hurt in the matter, and thankfully she's okay as well.
Yes,
That's all
no,
that's.
you're correct. That is a good, the best possible outcome, correct, yes. All right, please have a seat over probation. Somebody will be with you shortly. There's a copy of that.
Thank you, Your Honor.
You're welcome. All right, we are on the record, the matter of the city of Riverview versus Lisa Medell, 24326.
Here's piece of here, and I'm testing with my client, and this is the daytime runs up for a arraignment trial. I claim for what the charges are, right? And there's a reasonable reading standard. Take your name, man.
Lisa Medell.
All right, thank you. Terry, on your travels, can you ask Mr. Carmen to log in, please? Okay, thank you. All right, and so today's the date scheduled for arraignment pre-trial in this matter, and as to the arraignment counsel.
I said, Your Honor, we wait for a reading standard to explain to her what the charges.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and as to the pre-trial counsel.
Your Honor, the pre-trial matter with the prosecutor, his offer, which my client, Mr. Village, above, says he will plead guilty to the amended charge of disorderly conduct. She understands what that means, Your Honor. She understands the possibilities of the penalties. And we hope the court would accept that plea. If it is in fact accepted, the original charge of assault matter will be dismissed on the prosecutor's motion. That's family support here in the court.
And who is with your client in the courtroom?
I'm sorry, sir. What relation to you are you?
She's my niece.
Raise your hand, please. Okay.
What is your name, sir?
My name is Joseph Vitale.
Okay, can you spell your first and last name since you're not on the record?
Joseph is Joseph. Vitale, V is in Victor, Itale.
Okay, and do you live at the home?
Lisa's mother is my sister. She had passed away last month, and I'm the only one that I live in Ypsilanti.
Okay, so my question, sir, is to whether or not you live at the home. You don't live at the
I
home.
live at the home, but I'm looking after the home because my sister is gone, and I don't know if you know Lisa and Stephen Good and my sister.
Okay.
Gina.
Okay, thank you, sir. I just wanted to just kind of ask. I wasn't sure if you were and somebody from the home. Thank you.
Watching.
Okay, and so, Mr. Carmen, can you please place your appearance on the record?
Michael A. Carmen, 73824, on behalf of the prosecution, Your Honor.
All right, thank you. And so this is regarding Miss Medell. And have you already spoken to Mr. Phillips?
Your Honor, I did not, but as far as reducing it to a disorderly, I don't think that I need the victim's consent.
Please raise your right hand. Ma'am.
Raise your hands.
Do you solemnly swear or affirm the testimony about to give this matter be the truth, the whole truth, and nothing but the truth?
Correct.
Okay. Ma'am, are you currently under the influence of anything?
Am I right now?
Yes.
No,
So if you're to test right now, there's nothing in your system.
there's nothing. I did smoke some marijuana.
All right. All right, you heard the plea that was placed on the record, correct?
Correct.
As to the amended charge of disorderly conduct, how do you plead?
Guilty.
Counsel, if you can please swear to your client.
Ma'am, on March 14th, approximately 2:57 PM, were you operating a motor vehicle? Were you in the city of Riverview?
I was in the city.
And you were with, at a time with Joseph Phillips, correct?
Correct.
And you had an argument with him, is that correct?
Correct.
You had kind of a mutual affray, is that correct?
Yeah, we
You
both.
got kind of loud, correct?
Yes.
So if people were to pass by, they would maybe hear and be disturbed, is that correct?
Correct.
I'm satisfied, correct?
Well, I mean, okay, so the court's gonna say that it's satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. The court will also note, ma'am, that after review of the report, you could have really been charged with a felony, right? Because the phone could have been deemed to be a weapon. And I'm very familiar with this home, and there seems to be a lot of issues that come out of that home. Is that where you, how long have you lived there, ma'am?
I've been there for 15 years.
When was the last time you consumed any alcohol?
Last time I had alcohol, I had a beer yesterday.
What's that?
I had a beer yesterday.
Just one? That's yes?
Yes.
All right, we're going to schedule this matter for sentencing on May 29th. Is Mr. Phillips, is he still residing there?
He does not.
He does not live there.
He doesn't legally live there.
What does legally live there mean?
He's not on the house.
Does he sleep there?
No, not anymore. Not since my mom passed away.
This was your mother's ex-boyfriend, is that correct?
Yeah.
Because his driver's.
Sir, I can't have you shouting out. Thank you. All right, the court has completed the notice to prosecuting officials. And the court's going to order the following. I'm sorry, ask the bond counsel.
Your Honor, my client tells me she's not on probation or parole, no criminal matters pending in the state or anywhere. And we'd ask the court to consider a personal bond, Your Honor, court bond she agrees to respect the post under circumstances. She's just getting ready to apply for Social Security disability. She's not working at this time.
Ma'am, when's the last time that you worked?
2012.
2012?
Yeah, I've been staying with my mom for a while.
Okay, but staying with your mom, I mean, you still don't support yourself?
I have my bridge card, my brother has SSI, and I'm applying.
Okay, so ma'am, my question is supporting yourself. What you've told me is how everybody else is supporting you. And how the government's supporting you.
That's the answer.
I'm sorry?
Yes, I get government assistance.
So why don't you work?
I'm applying for SSI.
Okay. You've been disabled since 2012 when you last worked?
Not on paper, no, I just don't feel good.
Well, I don't know what that means. You just don't feel good.
I don't feel good.
Do you not feel good because of alcohol use, medication use? I mean,
What's the nature of your disability, ma'am? If you can tell the court.
They diagnosed me with bipolar and anxiety disorder.
okay. And so do you take medication for that?
Is that yes or no?
Yes.
Okay, and so, so you say you're in the process of applying for disability. What does in the process of applying for disability mean?
I have an appointment on May 20th, over the phone to do the application.
All right, the court's going to order a $5,000 personal bond with the following bond conditions. You're not to have any contact with Mr. Phillips. That's phone contact, text message, email, social media, third party, anything of the like. You are not to possess or consume any alcohol or drugs unless prescribed. You'll be subjected to random testing. You're also going to have an alcohol tether. And then you need to make sure that you are returning to court on May 29th, and in the meantime, you have to go over to probation and they will get you set up with your pre-sentence and investigation interview. Any questions?
Any questions, ma'am?
All right, just have a seat, wait for just a few moments for your bond condition.
Thank you.
Thank you. All right, we are on the record in the matter of the city of Wyandotte versus Natasha Azar, 232004. And counsel, your appearance, please. Counsel, your appearance, please.
Good morning, Your Honor. For the record, Marshal Garmo appearing on behalf of defendant Natasha Azar.
Thank you. And Ms. Azar, your name, please.
Natasha Azar.
All right, and so today's the date scheduled for sentencing in this matter. Ms. Azar was originally sentenced to the 25th District Court and Sobriety Court on September 11th. And she was to be released on GPS tether. And then I believe she began the program in October, and by November she'd absconded and cut off her tether. And it wasn't until she picked up another case in Southgate, 28th District Court, that she was brought back before this court. So it's my understanding that she's been removed from the program in 25th District Court, and so this court needs to resentence her. So counsel, have you had an opportunity to review the report and recommendation with your client?
Yes, Your Honor. And I'd just like to make some comments about the recommendations. Your Honor, some of them.
Hold on, counsel. Hold on. Before we get to that, are there any corrections that need to be made on the report? On the report?
No, Your Honor, not at this time, no.
Okay. All right, then ask the recommendation, counsel.
Your Honor, with regards to the first item is incarceration. I don't know what the probation officer meant by that. Does that mean time served? Because if she is getting more incarceration, then a lot of things here from number 2 to 6 would not be possible, given that she is incarcerated. For example, the other things that she has to do, Your Honor. So, I'm just asking that this honorable court for time served instead of any other jail. Your Honor, a lot of these.
You're asking for what? I'm sorry.
Your Honor, I'm asking for time served.
Time served and no probation?
Your Honor, she's going to be on probation for 2 cities, the 25th District Court and the 30th District Court. So to avoid 3 probations, 1 probation would be more than enough. She's very serious about moving with life. She wants to go to college. Your Honor, Natasha suffered severely years ago. I cannot tell you what it is, but if her mom is in court, would you kindly allow her to approach for just a minute and tell you what happened? That caused this young lady just to go through a lot of severe pain. Not physical, of course, and
okay, Ms. Azar can't tell the court herself. She has her mom. You want her mom to tell the court?
Your Honor, Mr. Azar, it's a very private and confidential matter. What happened to her years ago, with her mom in court. Actually, we did bring this to the attention of the probation officer. What happened to her? So I believe this goes some of these bad things that she made the decision she took at that time.
Okay, counsel, here's what I'm slightly confused about. You're telling the court that there's something that's been, there's something that private that happened to her that you don't want her to talk about, but her mom to talk about.
You know, it's not right to talk about it. Just tell me what happened. The probation officer, she does mention it, but she did mention it in a way that because I know what happened, nobody else would know what that meant. I think that is the probably page 2.
Okay.
Your Honor, I just leave everything to your discretion. I've been coming to your court. I have a lot of respect for you, and Your Honor, I press your decision. Well, I'm asking you to give her a chance to move on with life. She's really very, every time I see her in the jail, she wants to go to college, and her mother, she says she will take care of the tuition and everything.
Okay, what is your client currently on probation for in the 25th District Court?
Your Honor, 25th was the position of certain drugs possession under YTA. The other charge was dismissed. The same thing, Your Honor, for the 30th District Court. There were 2 misdemeanors, 2 or 3, I'm not sure, but they were dismissed. She pled guilty to 1 under YTA. So now she's only has 2 YTAs, and these 2 cities she will have spotless record. Of course, aside from this court.
So the one from April in Southgate, you're saying that that's YTA?
Yeah, the only remaining charge, Your Honor, is under YTA, correct. A misdemeanor.
And all of these appear to have drug charges associated with them.
Your Honor, it was possession, just to be clear, possession of drug paraphernalia, things like that, yes.
So Natasha,
Yes, Your Honor.
how many days have you been in the Wayne County Jail?
I'm not too sure. You're gonna have to ask my lawyer. He has the exact number.
Okay. And your attorney's saying that you want to go to college.
Yes.
Okay. What do you want to pursue? What degree?
I want to be a neuroscientist, so I'm going to start by taking pre-med, and I might also bounce on sociology on top of that, but for sure pre-med, because I might not be able to take 2 classes at once, as that is kind of a struggle. But my end goal is to be a neuroscientist. That takes 12 years of schooling. And I'll be immediately working as soon as I get out at metal manufacturing.
What?
Metal manufacturing.
Okay. And how do you know that you have a job there?
I've already talked to the owner.
When did you speak to the owner?
I was working there before incarceration.
Okay, well, that would have to be something that we have to correct, counsel, because that shows that she worked with her mom and sister. What's the name of your company, of the company you worked for, ma'am?
It's metal manufacturing.
Okay, and Mr. Blackburn, who is Mr. Blackburn?
My ex-boyfriend.
Your ex-boyfriend?
Yeah, we no longer talk.
Do you work at metal manufacturing?
No.
And so you're on probation out of the 25th District Court?
I believe so, yeah, I think it's the 25th.
I don't believe that you're on probation yet.
The 25th is at Southgate?
No, that's Lincoln Park.
Oh, I'm on probation for Southgate. My Lincoln Park is, I have court for right after this.
Okay.
Your Honor, may I?
Yes.
Your Honor, the judge on the 25th District Court wants us to go to the court on Zoom, of course, and for sentencing, because he said, I want to know what Judge DeSantis is going to do, and he's going to be sentencing her today as soon as we're done in this hearing, Your Honor.
Right, but so she's not currently on probation with the 25th District Court.
Not yet, Your Honor, no.
Right, and so perhaps maybe she won't be on probation if I sentence her to probation. I don't know, but you indicated that both, that she was on probation in 25th and 28th District Court. But she's not on probation in 25th District Court yet.
It was misunderstanding. That is correct. She will be sentenced immediately after this hearing, Your Honor, according to what the judge said when we were in court.
So let's see, you were in this court on April 16th on tether violation. That's 21 days jail. So ma'am, the court does have some concerns given your drug use and that you need some significant assistance and support in maintaining your recovery.
I'm going to be pursuing counseling as soon as I get out of incarceration as well. Both family and individual.
Do you have a valid license?
No, but I'm going to be working on that as well when I get out.
Why do you not have a valid license, ma'am?
I've been too nervous to take the test as I don't have practice driving, but my mother has promised to help me when I get out. I've got my permit 3 times.
Here's what the court's going to do. The court, after hearing from counsel, hearing from Ms. Azar, reviewing the report, the recommendation, and this matter being a loitering of drugs or kept, used, or sold, the possession of drug paraphernalia having been dismissed, a review of Ms. Azar's criminal history, knowing that she was sentenced to the 25th District Court sobriety court, she absconded, cut off her tether. The court finds that there's reasonable grounds to depart on CL 76925. The court's going to order 24 months probation. You're eligible for early discharge, and I'll go over that in just a few moments. You're not to violate any criminal law of any government. You're not to leave the state without the consent of the court. You are to report truthfully to your probation officer as often as your probation officer may require, in person, writing, or virtually. You are to notify your probation officer immediately of any change in address or employment status. You're not to use any alcohol or drugs unless prescribed to be subjected to random testing. The rehabilitative goal for that condition is so the court can monitor your progress and maintain your absence and sobriety. You are to enroll and participate in intensive outpatient substance use counseling. The rehabilitative goal for that condition is to assist you in providing coping mechanisms so you can maintain sobriety and prevent relapse. The court's going to also order you to participate in the fan meetings once per month. The rehabilitative goal for that condition is to provide you with an additional support system so that you can work on your recovery as well as additional recovery resources. You are also to enroll and participate in mental health counseling. The rehabilitative goal for this condition is so that you can understand what your mental health needs are and you can get some support and treatment towards treating those issues. You're not to have any contact with Brian Blackburn. Phone contact, text message, email, social media, third party. Do you understand that?
Yes, Your Honor.
You're also to participate in 100 hours of community service. The rehabilitative goal for that condition is to help you further develop work and life skills to give back to the community. You are to seek and maintain full-time employment. I understand that you stated that you have employment.
Yes, Your Honor.
But in the event something happens, right, you need to provide proof of completing 30 job applications per week until the date you actually start work.
Okay, Your Honor.
The rehabilitative goal for those conditions is so that you can gain resources to provide stability. Any questions regarding those terms and conditions so far?
No, Your Honor.
So here's what I'm also going to order. I'm ordering 60 days jail, credit for 21 days. I'm also going to say out of the balance of the 39 days jail that we are going to we are suspending 30 days. So you have 9 more days to serve, ma'am.
Okay, Your Honor.
And there will be a jail review on that as well. Now, what that means is that if there's a violation, ma'am, of any of these terms of probation, you will be serving those 30 days.
Okay, Your Honor.
In addition to any other time. Do you understand that?
Yes, Your Honor.
And I'm also going to say this, that the information that I had received was that after you cut off your tether, you went back home to your mom's house, correct?
No, I didn't go back to my mom's until about half a month in. A month.
Okay. But in any event, you still were an absconder and you weren't here in court. Your mom didn't bring you here to turn you in or anything of that nature.
No, I only came to visit her for just a second to let her know I was okay. I stayed at a friend's house on Southgate.
Okay. Let me be very, very clear with you, ma'am. You've now been in custody in the Wayne County Jail for probably a little over 21 days because you were in there on your matter in Southgate. I'm going to venture a guess that you're not enjoying your time in the Wayne County Jail.
No, ma'am.
When, not if, but when you get the desire to use crack cocaine, crystal meth, anything else, alcohol, marijuana, anything that you do not have a prescription for, ma'am, I want you to think about how you felt while you've been in the Wayne County Jail.
Okay, Your Honor.
Because you will be back there if you violate this court's orders, any condition.
Okay, Your
You
Honor.
understand all that?
Yes, Your Honor.
This court's also going to add a condition of mandatory jail for any violation. Ma'am, you have your mom and your sister in your corner.
Yes.
At some point, they are going to be done.
I
They
know.
are beyond exhausted. They are beyond exhausted. It's not fair for you to take all of your mom's energy and resources. So you are being provided with the tools to move forward. And yes, things that have happened in your past are tragic. There's zero way to change that it happened.
Thank you for this opportunity, Your Honor.
All right, the court's going to have you, when you are out of custody, so in 9 days, when you're out of custody, you need to come back to the 27th District Court Probation Department to receive your instructions and all that information.
Okay, Your Honor.
So I'm going to order defendant to report to probation within 24 hours. Well, let me say, in 24 business hours of release. All right, the court's going to order a $300 fine, $100 screening assessment fee, $1,200 supervision oversight fee, that's $50 a month, times 24 months. And since some of that may not be due because you would be able to discharge early, it could be up to $600 that may not be due. Okay, ma'am? $300 to cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50, which will $2,125. Now, I'm going to order that you are to set up a payment plan through probation by July 1st. That should give you time to establish some, well, actually, let me do this. I'll do August 1st. That gives you time to establish work, receive some paychecks, and figure out what your budget's going to be.
Okay, Your Honor.
Anything else?
No, Your Honor.
Any
Thank you.
questions, counsel?
Your Honor, thank you.
The court wishes you well, ma'am. You are going to have significant supervision.
I appreciate this offer again. Thank you so much.
You're welcome. All right, good luck to you.
Thank you, Your Honor. All the best to you and your staff.
Thank you, you as well. Okay, and I apologize for your delay today, counsel. I know that you've been here for a little bit. All right, Mr. Lambert, your name, please.
Kenneth Lambert.
Okay, please remove your hands from your pockets. And so today is the date scheduled for the adjourned pretrial. And counsel?
Yes, Judge, in interviewing his client, Mr. DuBois, discovered that likely the client is not going to be entitled to appointed counsel. As such, he advised them to retain their own counsel. They did so, but were unable to do so until this past weekend. I filed my substitution of counsel. At this point, we have one outstanding matter, and the prosecution has indicated that they're going to get the video to me, but to date it was not delivered to Mr. DuBois. That video apparently contains images of my client doing what he's alleged to have done, and I would need that to prepare for a trial. Unfortunately, we are unable to reach an agreement on a plea, so we're asking for time for me to review and file likely a motion for a dismissal here, where there's actually no property actually destroyed. And then if the court would like to set a subsequent trial date.
All right, well, let me just ask this question. Mr. Carmen? All right, so here's what I'm concerned with, counsel. Well, the court will grant will sign the order of substitution. Discovery was ordered in this matter back in January 24th. And so you're telling this court that that the discovery hasn't been obtained?
Well, not exactly. There was a copy of a file that was provided to Mr. DuBois. That was provided, I believe, by the detective on the case. Unfortunately, that same file was sent to me, and I was able to confirm that the file is corrupted in some way. It's unopened. So I'm
Been unopened?
unopenable.
Oh, not, okay.
It cannot be extracted, and that's what the devices all say, is that it failed to extract the file. Mr. DeBloy contacted the detective in the matter and sought to get another copy that was good, and was told he wasn't going to get any cooperation from that detective on the matter. Now, I've spoken since to the prosecutor today, and they've indicated that they would cooperate in getting me a good copy of that file.
Mr. Carmen, your appearance for the record, please.
Michael A. Carmen, P7324, on behalf of the prosecution, Your Honor.
Okay, so this matter has been pending since, well, the first court date was January 24th. The court did order the parties to attend mediation. We adjourned this to March 25th, and then we had adjourned it again to April 8th due to mediation, or to continue mediation. Then on April 9th, the parties, there was a pretrial held, and it was adjourned until today's date. And so I see that there's a request to adjourn this for 30 days. I can't go out another 30 days, counsel. This has been pending for a very long time.
That's fine.
Here's my question. What is the likelihood, and I'm sorry, Mr. Carmen, how long will it take for that discovery to get to Mr. Britton?
Your Honor, I did just have the detective re-email me the Axon link. I opened it on my laptop and got it to work. So I would assume he shouldn't have any problems opening it.
Okay, so has that now been sent to Mr. Britton as well? It was sent to you and to Mr. Britton?
No, just to me. I need Mr. Britton's email address.
Okay, you guys didn't exchange that when, how else
I
were you going to get
got my card
discovery?
on the way out, yeah.
How else are you going to get the discovery on email if you didn't give him your email address?
My email's in the bar journal. I've sent you.
No, that's true.
I can just get it from the bar journal. Just spell your last name for me.
Yes, Brittain.
Okay.
All right, so I'm going to adjourn this. I'll adjourn this to May 20th. That way, council gives you time to review the discovery and draft any motions if you're so inclined to do so. And in fact, I'm going to set this as a final pretrial. I'm not going to continue to adjourn this. It'll be a final pretrial.
Judge, I am being talked to in my ear, and I've given the delays in the case already. I'm not sure if this is going to make a difference. But Mr. Lambert is missing work for all of these dates. In June, he is going to be off of work and able to make the court dates without missing any further work. If the court would consider that and setting the adjourned date, I appreciate it.
Well, and counsel, Mr. Lambert, I can appreciate that. However, there are time standards that the Supreme Court sets down on courts. We're already beyond that, and I can't go much farther beyond that.
I would only further note that the delays in the case are not the cause of the plaintiff. I believe it's the cause of the discovery being delayed here. But again,
Well, no, there was a time because this court ordered the parties to attend mediation, and so that was a reason for a big purpose of that, and that is because this is a matter that involves two neighbors.
Yes.
And so the court thought that was an appropriate means to that, and I thought that it had been rectified, but I don't really remember why.
No, apparently there's some dispute over the screws. The post had been.
The screws, we're continuing this case over screws?
As far as I know, and the prosecution, given what's happened so far, has not offered to dismiss the case, given that the remedies have been followed through by the Lambert. So it's their purview or their decisions as a trial.
Mr. Carmen, what still needs to be resolved? The charge in this matter is malicious destruction of property. And if I recall correctly, there was a desire to have the property returned to its reestablished. And there was a mediation agreement that everybody signed.
Your Honor, Ms. Smiley, the complaining witness in the case, wasn't satisfied with how the mailbox post and I guess trying to think of the word really, but just wasn't satisfied with the remediation. She is here. If you'd like, I can get her and bring her into the court and have her explain it to you herself.
Okay,
Do you want to do that?
yes, Ms. Smiley, are you in the courtroom?
She is upstairs. I will go get her and bring her in, Your Honor.
Okay, I'll recall this matter when she comes down. I
understand.
You know, I just want to kind of get a gauge as to what we're utilizing the judicial resources for with this case, so.
From my position, they either want to prosecute them or they don't. It makes no difference to me at this point.
Okay.
We'll do what you want.
All right, we'll recall this matter. We're on the record. Okay. All right, let's recall. Mr. Wright, please join the breakout room. We're going to recall the matter of Kenneth Lambert, 232561. And Mr. Carmen, can you jump into the courtroom, please? Okay, well, we'll recall this one again in a minute. Oh, is Mr. Carmen on his way in with you as well?
He, I believe, was going to grab a screw from the court officer.
A screw, okay.
I want to carry it in. Yeah, I'm in court.
Counsel, I've called this case. Counsel, I've called the case and we're on the record. And so you just stepped out from right here and answered your phone while we're on the record in court.
I apologize. I answered it because I have another client that I suspect may be going to jail today in Monroe. I will not do so again. I
So
apologize.
counsel, then what? The way that should have happened is you could ask the court for permission to step away and leave the courtroom for a moment.
I will absolutely do so.
So, and then right now, you can go handle your conversation. I'm gonna call the matter of Deshaun James, 231017. All right, so we are recalling the matter of Kenneth Lambert, 232561. Appearance for the people, please.
Michael A. Carmen, P73824, on behalf of the prosecution, Your Honor.
Thank you.
James Burton appearing on behalf of the defendant, Your Honor.
Thank you. Mr. Britton? I'm sorry, Mr. Lambert, your name again, please.
Kevin Lambert.
All right. And so counsel, so Mr. Carmen, I asked Mr. Britton what the issue was because there's a mediation agreement that's signed by all parties. And so actually, I'm going to do Mr. Britton and Mr. Lambert, I'm going to have you go over to the table over there. And then that way, Ms. Smiley can go to the table with the prosecutor.
Your Honor, do you want me to have her stand at the podium?
No, that's fine, right there.
Okay. I had Ms. Smiley here as a victim of the case, and she can fill in the court much better than I'd be able to.
Well, counsel, I'm just asking if there's a mediation agreement. Is there something that has not been complied with in the mediation agreement?
That's what Ms. Smiley is going to testify to, not comply with to her satisfaction.
To her satisfaction?
Yes.
Ms. Smiley, so we're not doing testimony or evidentiary hearing. I'm just trying to figure out, ascertain where we're at with this so I know what direction we're all going. And so Ms. Smiley, can you please state your name, your first and last name for the record?
Heather Smiley.
Okay. And the mailbox was repaired, it was put back on, correct?
Temporarily, yes, ma'am.
What do you mean temporarily?
So, Mr. Lambert, or I offered to replace the platform in October, and I actually purchased the wood, prepared it, it was all ready to go. And I approached Mr. Lambert in October, and I told him that I can do the work, but I can't touch the mailbox because it's federal property. And one of two things had to happen. Either he removed his mailbox from my platform so I could replace it, or he would give me a letter saying that he would give me permission so that I would have it in writing because I didn't want to have any issue with
Okay, let me ask this question. You all went to mediation, correct?
Correct.
Okay. And at mediation, there was an agreement that was signed.
Correct.
And then Mr. Lambert was going to put the mailbox back up.
Yes, ma'am.
Okay. Is the mailbox back up?
My mailbox is not currently up, no, his is, and he did replace the wood. But,
So why is your mailbox not up?
I'll explain that, ma'am. There's a, Mr. Lambert, said that his side of the wood platform was rotten. So he took a new piece of wood and he screwed the new piece of wood to a rotten piece of wood. So my concern is that when the snowplow comes in the wintertime or whatever, if you take something new and you screw it to a rotten piece of wood, it's not gonna last long, and I don't wanna be back in here at the court again. What should have happened is the rotten piece of wood should have come off with the 4 lag bolts that hold it on there. But instead, Mr. Lambert took a new piece of wood and screwed it with small screws into the rotten wood on top of the bolts of the rotten wood. So the reason why we didn't wanna put our mailbox on is because we didn't wanna be here in 3 months or 6 months because the whole thing fell apart.
Okay, so here's what the mediation agreement reads. The Smileys will remove their mailbox from the mailbox pool sometime on Friday, April 5th. The Lamberts will purchase a new platform/base, and the base shall be of such grade as pressure-treated or womanized lumber. Counsel, was that done, Mr. Britton?
Judge, I haven't reviewed it,
Yes.
okay.
You what?
Yes, she says yes. Yes, it was replaced with the type of lumber that was agreed upon in the mediation agreement.
And so then the Lamberts will replace the existing base material with the new base material, remount their mailbox to the new base. The Smileys will then remount their mailbox on the new base. So, Mr. Lambert, did you purchase some pressure treated or womanized lumber? Or did you use the material that was left there by Ms. Smiley?
It was new wood was used, Your Honor.
So, Counsel, what I'm hearing is that Ms. Smiley is indicating that new wood was purchased, but she isn't satisfied with how it was installed.
Correct, Your Honor, and I do have a printout that Ms. Smiley put together with just an explanation as well as some pictures and graphics. If I can approach and show that to the court, I think it
Did you show that to Mr. Britton first?
Did you show? This should be done at trial.
Hold on a moment, hold on. What I'm trying to do is I'm trying to avoid using judicial resources over what type of material was used to put a mailbox back on. The parties went to mediation.
Yes, it's our position.
Counsel, please don't interrupt me. The base material was put back on so that the mailboxes could be remounted. Ms. Smiley is stating that she doesn't like the way that it was put on or the type of material that was used because there could be an issue when it snows with a snowplow. So I just want to understand, we are going to utilize judicial resources over a trial if there is not a resolution, which it appears based upon the mediation agreement that there was a resolution to this matter. So we're going to utilize judicial resources on this issue. Is that what I'm understanding?
You'll have to ask the prosecutor that. It's his judgment.
I believe it sounds that way, Your Honor. Just what Ms. Smiley has handed me and indicated to me is that while where there was a mediation agreement, what was performed was not done in a workmanlike manner.
There's nothing on this mediation agreement that says workmanlike manner. And so now we're going to move forward with a trial, and I'm going to presume it's going to be a jury trial on a workmanlike issue or types of materials that are utilized.
Well, we're going to trial on malicious destruction of property charge.
Counsel, please stop interrupting me. I've already said that. That would be the reason why there's not a resolution when the court ordered the parties to attend mediation because it's a neighbor dispute. And Mr. Lambert was subsequently charged with a criminal matter because the parties share a mailbox post platform. And he took it down allegedly, and that started issues regarding this. So I just want to understand that we are going to utilize judicial resources for this issue with this charge. Is that what we're doing?
I'd say so, Your Honor. But maybe if there could be a way where we could have the court evaluate if the mediation order was complied with that way. I think sending this for a jury trial would be a bit too far. It's got
Well, the court also-
but I would request.
Well, the court agrees that all the resources that have been expended at this point is a bit far, because the new platform base is a pressure treated or womanized lumber. It's been installed. Mr. Lambert has remounted their mailbox. Now we're just waiting for Ms. Smiley to remount her mailbox. And so there's not a resolution offered or which this court was of the understanding that that was going to resolve everything, and then the matter would be closed and concluded and not moving forward. But that isn't happening, it appears, because Ms. Smiley is not satisfied with how it was done.
Correct.
Okay, there's nothing in this mediation agreement that talks about workmanship or how it's to be done.
And
So I would expect that as counsel, as the attorneys, that you are having conversations with your respective individuals so as to come up with a resolution so that we're not utilizing judicial resources over this matter, because the two of you or the four of you or whoever, and when I mean four of you, I'm not talking about counsel, I'm talking about spouses, cannot figure it out and somehow get along, or just at least because you're neighbors, civil or cordial or what have you. So we're going to schedule this matter for a final pretrial on May 20th at 9:45 a.m. Hopefully things have been resolved by then, otherwise we'll have to move forward and that doesn't make.
here, and just for the record, I did send Mr. Britton the video discovery.
Okay, you have that, Mr. Britton?
I did receive an email. I'll have to wait until I'm back. I wasn't able to open on this device. I think I can on my computer. If there's any problems with it, I'll contact the prosecutor and we'll work it out.
Okay, and counsel, again, in the future, if you have a phone ringing, ask to be excused so you can leave the courtroom instead of answering it in the courtroom when I've already called the case on the
My
record.
apologies again.
All right, thank you. On the record in the matter, we're recalling the matter of City of Riverview versus Unique Kennedy, 24321.
Ready? Chief Rao, 33828, appearing on behalf.
Hold on. No, everybody right back up here. Right back up here. Ms. Lambert included. Ms. Smiley, you can come back up this way. Ms. Lambert, please, we're recalling the matter of Kenneth Lambert. Ma'am, please state your name for the record.
Kathy Lambert.
Okay. So I'm going to place on the record, because I don't know that counsel saw this, but the court was watching the body language and the behavior as Ms. Smiley as the parties were leaving. Mr. Lambert was walking back to his wife, and then Ms. Smiley was walking out. Ms. Lambert apparently found it necessary to stare her up and down and stare at her as she was walking by.
Can I speak?
No, you may not. You may not. There is no need for that at all. At all. None. Perhaps that's why this matter hasn't resolved. I don't know. But it needs to stop. You are utilizing judicial resources, right? for a matter that has occurred between two neighbors that started, or at least in this matter, with removing a mailbox. There is no need to look at her at all, to attempt to make any eye contact. At all. Ms. Smiley, next time, please wait until they leave or ask somebody if one can leave first or what have you. Whether any body language or facial expressions are reciprocated, it all needs to stop. And the fact that that's occurring right here in the courtroom tells me that there's other things that are occurring at the homes, which is very problematic. It needs to stop now. It needs to stop now. You don't like your neighbors, you don't like your neighbors. You don't have to engage with them. But if you share a driveway and you share common ground, you're stuck or you move.
And Your Honor, if I could just add quickly, of course, the city doesn't need to tie up any unnecessary judicial resources in any of this, certainly. But I personally did not observe what happened because my back was to it, but it seems like a microcosm of what this woman has been dealing with her neighbors. So unfortunately, it's that type of behavior that's mandating the judicial resources being used in this case.
And I hear you, counsel, but I'm also aware that there are three sides to every story. One's perspective, another's perspective of what's really going on in the middle. So I'm going to presume that this is not all one-sided. I don't know what side is heavier than the other. I don't know, but it all needs to stop, all of it. We'll see you back May 20th. And we're back on the record in the matter of Unique Kennedy.
Ready?
So Ms. Lambert, I'm going to have you exit first. Ms. Smiley, I'm going to have you just wait just a few moments.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're gonna start bringing people in person. People are gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs to drink.